The last time you were here in court, sir, which was April 20th, there was significant disruption to the court record. So I'm going to state this. If there is one interruption by you with anybody that's talking on the record, you will be held in contempt of court. Okay, I did confirm that, yes, the complaining witness or the prosecuting attorney was notified. And then is this the complaining witness that's in the courtroom now?
No, that's her attorney. Or at least so.
Okay. I also have information that she's supposed to be here. She was even here last week when she wasn't notified. It wasn't moved. So
an hour and 10 minutes after.
I understand, but I know that well, from what I was told, she was going to be here. Good morning, Mr. Kazak.
Good morning, Your Honor.
All right, so we are going on the record in the matter of the state of Michigan versus Shadid Howard Randolph 23302. And appearance for the people, please.
Good morning, Your Honor. Please, people P 214.
And counsel.
Good morning, Your Honor. Mr. Shanky, can I have my client who stands to my immediate right?
Thank you. And Mr. Howard Randolph, your name, please.
Shadid Howard Randolph.
Okay, so before we go any further, I'm going to make this statement. And I'm going to indicate the last time you were here in court, sir, which was April 20th, there was significant disruption to the court record. So I'm going to state this. If there is one interruption by you with anybody that's talking on the record, you will be held in contempt of court. Do you understand that?
Can you repeat it again? Did I do something wrong, you said? You said I did something wrong?
What I indicated is the last time you were here in court on April 20th, there was a lot of interruptions. Not a disastrous record. We had a disastrous record. So what I'm indicating, so I can make sure that we have a clear record and that I am maintaining order in the courtroom, that there will not be any interruptions by you, whether when the prosecutor is talking, your attorney is talking, any other witness, or myself. If there are any interruptions by you, Mr. Howard Randolph, this court is going to hold you in contempt of court. Do you understand that?
Yes.
And Your Honor, my client understands that I will be speaking for him today, pretty much for the majority of this, for this proceeding. So I don't believe that's going to be an issue. But thank you, and we're well noticed that everyone has to wait their turn to speak. Thank you for the notification. No, you cannot. You just were told no interruptions. Just stand there quietly. I will do all the talking. Just interrupted me, and that's something you said you weren't going to do. I'll do it. We're ready to proceed, Your Honor.
All right, thank you. And Mr. Kazak, are the people ready to proceed?
Your Honor, the complaining witness is not currently present. I'm not sure why she's not here. I do know Laura, our victim advocate, did contact her, and she did indicate that she was going to be appearing. I would ask the court at this point either to rely, we would ask the court to amend the evidence, the initial bond violation report, which is the Macomb County Sheriff's report, case number, complaint number 39309-23, as a basis for the bond violation. So we ask the court to rely on that this time. I would prefer to have the complainant present, Your Honor. I'm not sure exactly why she's not here, but given the fact that this report concerns contact by Mr. Howard Randolph with the complainant, my concern is that there may be reasons why she's not here directly related to this report, especially his continued contact of her in violation of the court's order. So I would ask at this time for the court to rely on that report as a basis for the violation. and to consider it in deciding whether or not Mr. Howard Randolph violated his bond conditions.
I thank you. And Mr. Tumke, your response.
Your Honor, in this circumstance, we don't know the nature of what happened on that date and time. We have a police report with allegations. Complaining witness is not here. We were here timely at 8:30. We're now an hour and 15 minutes past that. My client understands that there's no contact condition. He understands that any contact, whether initiated by him or in response to the complainant, is a violation. Judge, I'd ask that at this time he be instructed but not admonished as we waited timely. It's my understanding that there's been 2 proceedings the last couple of days. The complaining witness has been present. The victim advocate is present. I'm present. Another agent for the complaining witness is present. She has failed to appear. And without her testimony, there's no way to determine exactly what happened. We don't know. My client initiated. We don't know if she was contacting him. We don't know if it was over concern of the child. We simply don't know. I'd ask that he be instructed, no contact, which is very clear. And obviously any sort of further contact, we'll find ourselves right back here. But we have a court date scheduled. My client's maintaining his innocence. He understands that there is to be absolutely no contact and that there are severe ramifications regarding any future violations. I'd ask that he just be instructed today and then be given an opportunity to maintain his innocence. Since I've had an opportunity to review the case with him, he and I speak daily. I don't believe that there's going to be issues with the court going forth. I don't think there's going to be any issues with any bond violations going forth. They're handling their child custody issue. It's separate. Seems to be working out, at least potentially in a positive way. Hopefully they find a resolution. And in the meantime, he's maintaining his innocence in this case. I'd ask that we are allowed to proceed with that innocence with the understanding that future violations will just bring us back here, or even allegations thereof.
All right, thank you. And then I see that there's an individual here, man with a burgundy jacket. Can you please step forward?
Good morning, Your Honor.
Good morning. And what is your involvement with Ms. Pamela Duff?
I am representing her for the custody case in Louis County Circuit Court.
Okay, when's the last time you had communication with Ms. Duff?
I spoke with Ms. Duff yesterday evening.
Okay. And based upon your conversation, do you have any reason to believe that she would not be appearing here today?
No, Your Honor, my understanding was that she would be appearing. We are in the middle of a custody trial. We have 2 days of trial that will be continuing today. And when I spoke to her, my understanding was that she would be here.
When is the last, and so you last spoke with her last evening?
Yes, at 5 p.m. we adjourned trial.
Have you reached out to her this morning or attempted to reach out to her this morning?
Yes, I have.
And was it successful?
No, I have not been able to make contact.
Did you phone her, message her, email her?
I called her by
Okay.
telephone. But
Okay.
no one answered.
Did it go right to voicemail or did it ring?
It rang and then went to voicemail.
Were you able to send her a text message?
Yes, I did follow up with a text message. I have not received a response.
Do you typically text message Ms. Duff?
Yes, I do.
And when you text message her, does she reply within a reasonable time frame?
Yes, usually.
What is that time frame that she usually responds to you by?
It depends on the nature of the conversation. Usually, between, just a few minutes to an hour.
And when did you last send Ms. Duff a message this morning?
I texted her at 9:22 a.m.
Okay, so it's about half an hour ago. And you don't have any response from her?
No, not.
And does it show if it was delivered or not delivered?
It does show as delivered.
Doesn't, I don't know.
I apologize. I'm confirming. I'm not sure. Yes, I think it was delivered. I have no reason to believe it wasn't.
Okay, do you have an iPhone or an
Yes,
Android?
it's an iPhone.
Does Ms. Duff have an iPhone?
No, it's not an iPhone.
Okay, so it won't show.
Yeah.
Okay, Ms. Dodge, if you can step forward, please, and state your name and, yes, just don't go far, counsel, please.
Yeah, I'm just getting my call letter. Lord, I think, man.
Thank you. Have you had any contact with Ms. Duff?
I
Last time I talked to her was about a week ago. She's the one that told me about the adjournment for today. And then I called her, but her voicemail was full. So I emailed her, and then I emailed her attorney, and that's when her attorney said that they were together and that she. So I didn't personally talk to her. And I emailed her again this morning. And then I haven't heard back.
When did you send her an email this morning?
Probably around 8:30 when I got here and she wasn't here.
The court will note that Ms. Duff did appear last week because she was not notified that this matter was adjourned to today's date. You haven't received any response from?
No, I haven't. I just told her I would talk to her next week. I called her last week. She answered the phone. I asked her where she was for last week. She didn't know it was adjourned. And she told me the court told her that it was adjourned.
Right.
She would be here and see them.
Right, I believe it was, we changed the date because Mr. Howard Randolph was having a dental procedure that he submitted proof for. So we adjourned it to this week. And then there was we received notice regarding the trial or the hearing that was going on in front of Judge Cholak of the Third Circuit Court at 10 a.m. And since that was, or at 10:30 a.m., no, 10 a.m. And since that was on Zoom, the court set it for today's date at 8:30 because given the nature of the charges, the court didn't want to go too far out without addressing the bond violation in the charges. And Ms. Ozier, was that Ms. Duff on the phone?
That was not Ms. Duff, that was her mother, who has tried to speak to her, and she hasn't been able to get through her.
And how long have you been representing Pamela Duff, ma'am?
Since approximately November of 2022.
And is this inability to communicate something that's been common or not during the pendency of your representation of Ms. Duff?
This has not been common. I usually have the ability to communicate with the.
Okay, here's what the court's going to do. The court's going to proceed today without Ms. Duff. The court has some serious concerns regarding the safety of Ms. Duff, given the fact that Ms. Duff was present last week when she knew, to the best of her knowledge, that this matter was going forward last week. And given the fact that Ms. Ozier, as an officer of the court, has indicated to the court that as of yesterday at 5 p.m., Ms. Duff is going to be appearing. Ms. Duff's mom can't get in touch with her. Ms. Duff's attorney cannot get in touch with her. Ms. Dodge hasn't received a response back from Pamela. And given the nature of the allegations of the communications that are at issue with this bond violation, the court is going to proceed with this matter.
Your Honor, in this circumstance, I know that it's going to be more relying specifically on the police report. Is that the foundation of how the court's prepared to proceed?
Well, quite frankly, I don't think I need to even review the police report or rely on the police report. There are some attachments that have been submitted regarding communications from what appears Mr. Randolph to Ms. Pamela Duff.
Your Honor, in that circumstance, I've had an opportunity to review these allegations. In the circumstance, it could be a phone number associated with my client, it could not be, it could be a person using his phone. We simply have a lot of ambiguity here. And frankly, the biggest concern is about the complaining witness's presence. Perhaps the light can be shined upon it, and if there's not been an issue with her appearing before. I do not want to jeopardize my client's freedom based on allegations without people to substantiate it. So before we started holding what could be construed as potentially an incomplete proceeding, I have no problem with adjourning the matter so that we can do our own homework. Potentially, so we were under the circumstance that we were under the impression that the complaining witness would appear and that some light could be shined on. But I don't like the opportunity of not being able to cross-examine anyone. I have no idea if those text messages are from my client. If they're not, if his phone didn't go anywhere else, I'm of course going to have him maintain his right to remain silent. I don't need him to go on the stand and testify that he did or did not do something. So if the prosecution is asking for some more time to button this up correctly, I had no problem with that. I'd rather do this the right way, giving me a full opportunity to do a cross-examination if necessary versus going after pieces of paper. And if anything, normally I could object to an adjournment, but I'm not going to. I mean, if the prosecution, the victim advocate, and there's another individual representing her on another matter, have an opportunity to speak with her, they can find out, well, was she an emergency? Does she not want to proceed? Was she threatened? Let's find that out. And in the meantime, all provisions remain in place for my client understands no contact whatsoever. And should he violate it, right back here again. So I'm not asking for even a long adjournment. I'd be happy to work with the court's convenient, come back on any day, and then we can see if perhaps some more information we find out as to whereabouts and information regarding the complaint.
Mr. Kazak, your response to that?
Your Honor, I guess my only concern is that these are not the first I mean, this is I think the third report involving Mr. Shaheed Randolph. And my only concern is that even if the complaint's not cooperative, today she made this report with detailed allegations that only someone in Mr. Howard Randolph's position would know information concerning only the complainant situation and Mr. Howard Randolph. And the other consideration, Your Honor, even though she can't be cross-examination, there's no requirement of that for a bond violation hearing. The rules of evidence don't apply for a bond violation hearing. This is a police report that was submitted to the Macomb County Sheriff's Department, and that's made under threat of not perjury, but of a criminal offense if it's false. And so the fact that this is a police report that's made under those circumstances and that contains detailed information, particularly in the text messages themselves regarding something that only the defendant would have knowledge of or have connection with, I think the court can make a determination regarding the bond violation even without the complainant's testimony, even if she decided that she was no longer wishing to cooperate with prosecution.
And Your Honor, in response to Mr. Kazak, I would just ask for a weak adjournment in this circumstance because my biggest concern is that police report is a hearsay document. Now, it would be different if my client was charged with a crime and probable cause was established, but he wasn't charged in Macomb. We don't know. And I have no idea whether or not charges will stem from there or if they won't. But it really comes down to the fact that the prosecution is relying heavily on screenshots of incomplete text messages that cannot be substantiated without the complaining witness or potentially further subpoenas. And I'm happy to give the prosecution extra time. I'm not looking to delay or move this case back any further. I'd be fine with coming back here in exactly 1 week and revisiting the matter with my client, and we can make an informed decision because I think that would give me an opportunity to go further into the allegations and even see if there has been, because when Mr. Kazak says, yes, this is a police report that could stem to criminal allegations, yes, it could. It could also stem to filing a false police report. The claiming witness could have committed a crime. There's too much here, and especially when my client's not in custody, I'm not worried about his right to a speedy trial being infringed. I'm only concerned about his freedom being infringed, and I just ask that we have the proper opportunity, and I'm happy to bend over backwards regarding the prosecution's necessity of extra time and the court's convenience to come back here to make sure it's done right.
Mr. Kazak, do you know the name of the child that Mr. Howard Randolph and Ms. Duff have in common?
I believe, I'm not, Your Honor, I'm not entirely sure. Give me one moment.
Actually, Ms. Ozier would know that information. Ms. Ozier is an officer of the court. What is the name of the child in common that Mr. Howard Randolph and Ms. Pamela Duff have?
His name is Rio Randolph.
Okay. So here's what the court's going to do. The court is going to, take a brief recess. I want to check something, I want to check something out real quick.
And I do want to remind the court that we did schedule for 8:30, just because my client has the circuit court.
I understand. Ms. Ozier, is it possible that you can log into the Zoom for Judge Cholak out in the lobby for a moment, letting the court know that we're almost done here and that it should be just a short little while before Mr. Randolph can zoom in?
Your Honor, if I may, that shouldn't be an issue. The court was informed of this bond hearing, and for that reason said that we could continue with trial once this matter was finished.
Okay, and I'm presuming that that the matter for Ms. Duff and Mr. Randolph was not the only matter on the docket for Judge Cholak today, was it?
I am not sure,
Okay.
but regardless, he wasn't expecting us to return prior to 11 a.m. So
Okay.
we're still well within the time.
11, okay, I'm sorry, I thought it was 10 a.m., okay. All right, we're going to go off the record for a quick moment, and then the court will resume shortly.
Thank you.